Good afternoon, everyone. Although the weather outside demands that we relish the first rains of the season, the ongoing times and the pressing issues entailing call for greater attention. So, let's grab our cups of tea, mugs of coffee, pen and paper, and begin with the 11th session of the Triple E 5.0 Master Knowledge Series. On the topic, Legal Framework for PMLA and WMD Act, Guidance for Practicing Professionals. The topic chosen for today's session is not only a topic for the knowledge of professionals, but a matter of global concern. Aligning with the global thought and the intent of international bodies, the Prevention of Money Laundering Act 2002, that is the PMLA, and the Weapons and Mass Destruction and Their Delivery Systems Prohibition of Unlawful Activities Act 2005, that is the WMD Act, have been enacted. And the intent of these critical legislations is to strengthen India's national security and financial integrity. While the PMLA focuses on curbing the menace of money laundering and ensuring transparency in financial transactions, the WMD Act, as the name suggests, aims to prohibit and prevent unlawful activities relating to weapons of mass destruction and their delivery systems. Together, these laws reflect India's commitment to combating financial crimes and upholding international non-proliferation standards. Coming to the second part of the topic, the practicing professionals. Company secretaries, particularly those involved in cross-border transactions, trade compliance, and corporate disclosures, must be well versed with the provisions of these acts to ensure that their organizations do not inadvertently violate national security laws. A sound understanding of these legislations enables company secretaries to uphold ethical standards, ensure legal compliance, and contribute meaningfully to the national and global security agenda. This webinar aims to empower the professionals, such as company secretaries, to understand the scope and compliance requirements under these acts and serve as effective governance professionals and uphold ethical standards. Since, as compliance officers, it is essential that they play a pivotal role in ensuring that corporate entities operate within the legal and ethical boundaries prescribed by these laws. Before moving forward, I would like to welcome our esteemed guests for today. Mr. V. Elenchelian, Joint Director, FIU-IND, the Financial Intelligence Unit India, said by the Government of India, is the central national agency responsible for receiving, processing, analyzing, and disseminating information relating to suspect financial transactions. We welcome you, sir. Our next guest, CS Shweta Gokarn, a practicing professional, a certified AML specialist with over 10 years of extensive experience, an expert member of Startup Committee and International Trade and Commerce Committee of Bombay Chambers of Commerce. We welcome you, ma'am. And our third guest, CS Nehal Thakkar, Company Secretary and Mentor with more than 2 decades of experience and former Compliance and Nodal Officer of NSDL Database Management. A very warm welcome to all of you. As we start, I would like to request all the participants to share in their queries and we'll be taking them at the end of the session. We will be beginning with you, Mr. V. Elenchelian. You will be sharing with us the regulator's view on PMLA and WMD Act and its applicability on CS professionals. Over to you, sir.
Thank you, ma'am. Thank you for this introduction. And with me is Shivani Mageshwari. She is a Deputy Director with FIU India. She has been directly...
Welcome you, ma'am.
Thank you.
Okay, so thanks for the introduction, and you set the tone for this session, wherein ICSI takes this very seriously about the obligations and the compliance by their members. So it's good to hear from you, and I also see very well-known uh, practitioners who and mentors who have been lined up to speak after me. So I would just give a broad overview of the uh, the notification and gazette notification, which talks about certain obligations that are cast upon CS professionals. And there may be some nuances which may be we don't have time for discussion. Maybe as the course progresses, maybe some will be addressed by the speakers, and some we can discuss. And if we couldn't solve this, we can always we can collect it and we will get back to you. So that's how we can set these rules for this engagement. So with this, I would like to start my presentation. So I will share my screen. Okay. Yeah. Yeah. Is it visible, ma'am? Okay. Thank you. Thanks. So, as you all are aware, May 2023 notification, two notifications came, one on May 3rd and followed by next on May 9th. The first one specifically talks about inclusion of certain designated persons under Section 21WA, which empowers the central government to notify certain professionals and businesses to and cast certain obligations in line with the PMLA 2002. So enough has been said, and we have seen what are the activities that are covered. Particularly, I will tell what is the intent behind it, but these are all the activities that are basically covered under the said notifications. And uh, what are the five activities? The first one is buying and selling of immovable properties, managing of client money, securities, or other assets, management of bank savings and securities accounts, organization and contribution of creation, operation or management of companies, and finally, management of companies' limited liabilities and selling of business entities. It's all widely understood. And again, by another notification on May 9th, it has clarified certain activities that are carried out as a business, regardless of whether they are persons associated with these three institutes. But it classifies certain business activities to be also covered under PMLA, and obligations are cast upon them. And the second, since it's also part of today's discussion, it is Section 12A of Weapons of Mass Destruction Act 2005, which was operationalized by DO or order in the same year, 2023. There were certain guidelines which are put out, and I will share that one also. It's in the open source, and it details the activities that are to be taken by the members that are covered under the ambit of this act. And all the reporting entities that are part of PMLA, they are by default they are obligated to follow certain guidelines. So we will shortly have a discussion on that too. So this intent is that we last had every 3 years we as a country we conduct national risk assessment, which looks into various sectors of our economy, and we'll try to identify what are the risks, particularly which sectors are more prone to money laundering risks, and how various sectors can mitigate those risks by the intervention by the government and the participants themselves and the various stakeholders, how we can create a synergy in identifying and mitigating the MLTF risks. So it was broadly during 2022 NRA, it was brought out that corporate CS professionals and CAs and CWA and other trust and company service providers, which are so the so-called gatekeepers to the financial ecosystem, they are unwittingly part of certain schemes where legal entities are used to launder money. So this is something, given the size and scope of the activities that are carried out by this CSPs along with other such service professionals. So we need to be aware that there is some possibility that their services can be misused by these launderers and and also in the process of committing financial crime. So we must be aware of this fact, and we should have take minimum actions to make sure that our services are not used in this enterprise, right? So that was the intent, and there may be in the right in the whatever that is put in the writing in the notification, there may be some conflicts, and but overall theme is that we should aim to deny these financial criminals to misuse your services in various ways where you interact with them, and wherever you feel that your services can obfuscate the source and the source of funds, and also uh, try to block the law enforcement agencies from conducting their services in their investigation in meaningfully trace their origins. Then in those cases, it is the obligations are cast upon you to make sure that your services are not misused in that enterprise. Again, just so coming to leaving aside that technicalities, what are the obligations that are cast upon your CSPs? There are six broadly. It can be classified in six categories. First one is risk assessment, wherein you are requested to you should identify, assess, and take effective measures to mitigate your MLTF risk associated with your service. You may be a single profession. I mean, proprietorship. You may have a large firm employing hundreds of professionals. The risk assessment should reflect the size and the scope of services provided by you. Second is your appointment of designated director and principal officer. If you are a single practitioner, sole practitioner, there is no need for designated director. You can be a principal officer and you can report it in your capacity. And if it's a firm, there is a designated director would be someone senior enough who can, has oversight on your reporting to FIU India and other related obligations. So, principal officer is the nodal person who is responsible for ensuring all that AML related compliance are ensured at your firm. And third part is verify and maintain records and identity of all clients. This goes without saying. Even now, you might be doing it, but it is as per this law also you have to maintain. And whenever FIU India asks for it, you may need to share it in the requested format. And maintain record of all transactions. Again, this is also you will be doing it. And fifth one, furnish information of suspicious transactions through ICSI. So this is where the regulation slightly differs from regulations for financial institutions. They are supposed to file directly with us. Here, given the scope and the numbers of CSPs and the regular interaction that you have with ICSI, so you will be doing it everything through ICSI, which is the designated SRB here. And finally, evolve an internal mechanism to detect transactions as specified in the rule. So again, PML rules 2005 assist, it clarifies the act and provisions of the Act 2002. So you have to have an internal mechanism. That internal mechanism should be proportional to whatever that risk assessment that you have carried out in the first part that we have discussed, the point number one. It should complement the risk assessment that you have carried out. So these are all the six broad points that everybody should take care of, and it should tailor made to your respective practice, right? And another crux of our discussion revolves around suspicious transactions. It is what constitutes a suspicious transaction. So it is definition has already been given. So any transactions, including attempted transaction, you must keep in mind that attempted transaction also is falling under this obligation. So to a good person, I mean, a normal person acting in a good faith, if it gives rise to a suspicion that it involves proceeds of an offense scheduled scheduled to the act. So you might be aware of the predicate crimes. I mean, different jurisdictions have different ways of bringing predicate crime, different ways of bringing offenses under predicate crimes for ML investigations. In India, we have a list approach wherein there are set a number of offenses that are put into the schedule of the act, which constitute predicate crime that can be result in a PMLA investigation. So you must be aware that if you have a suspicion that that funds or such transaction involves some sort of connection to that crime, you have to file STR. It is a part of suspicious transaction report, or it is, or if some transaction appear to be unusually complex or unjustified, or if a transaction doesn't have economic rationale or bona fide purpose, or finally, when you suspect there is a reasonable ground for involvement in a terror financing activity. These are all the four broad uh, points that you need to consider when you form an opinion about whether a transaction is suspicious or not. So this is coming to risk assessment, because this is something that every one of you have to do. So we will discuss, I mean, a bit more in a detailed fashion what actions are involved in this risk assessment exercise. So it's not very complex. If you see, it's very no nonsense activities that we can do. Everybody can do. It involves looking at your firm and what is the scope of services that are offered, and who are your customers, and what are the countries of operation of the clients that you are serving. Say, for example, let us start with the countries of operation. It's very simple. If you see FATF, I think you will be aware of FATF. It regularly monitors the countries for their compliance with money laundering laws. So there are blacklist, grey list, and blacklist and grey listed countries, which are prominently featuring in our press, wherein there are some observed deficiencies in their jurisdiction and yeah, and what do you call that, the in combating money laundering activities. So when your clients or any activity that has bearing on that countries, you have to be very sure, you have to take enough care to classify it as a high risk or medium risk. And if the customers are also operating in from such jurisdictions, you have to make sure that it is properly documented as high risk. And sometimes customers may not be directly involved in the type of activities that they are seeking from you. They may be acting on behalf of third parties, and some other, they may be strawmen acting on behalf of third parties. So you must be rightly aware of the customers. When I say customers, you should have a benefit. In case of legal entities, you should have enough information on the beneficial owners. Not only beneficial owners, also the control who exerts a control on that entity. So that you must be very sure about that. And in case of services, sometimes your services may be very, I mean, normal services, which is within our country, or it's just very simple, in line with complying with various regulations. But sometimes your services may include incorporation of companies, or dealing with real estate, or it may involve establishment of trusts, or acting as nominee directors, and structuring various corporate transactions. There are a number of services that may involve, I mean, multiple complex stakeholders. There, you have to be confident that you are having enough controls put in place to ensure that you have enough information on the legitimacy of the transactions, right? In this exercise of risk assessment, you can also take information from NRA, that is National Risk Assessment, that I earlier mentioned. That can also be used for your companies or your firm's risk assessment. It gives you broad overview how this sector as such has been misused, and you can take relevant portions from NRA and incorporate into your risk assessment exercise, right? And in addition to that, we regularly provide guidance, typology report, red flag indicators, and forward FATF reports. Already they are available in open source, but still FIU India also shares these type of reports on our website, that is Finnet 2.0. In your case, we will be sharing it with ICSI, and you can always reach out to them for any assistance with respect to your internal risk assessment. And once you have identified your what are the risks that you have, and you can put in place a certain checks to avoid. Either you can stop serving such, I mean, taking up certain activities that unnecessarily increase your risk, or you can continue that activity provided you put in place enough internal mechanism to mitigate those risks. And once you have put in it, you have to make sure you have policies and procedures that are properly documented, and you have to routinely check whether these documents and risk assessment is in line with ongoing services. Again, to reiterate that sole practitioner would not, we are not expecting that every individual sole practitioner have to have very high level of this thing. It's evolving situation. You start by fulfilling that basic obligations, and basis our constant discussions and handholding, you can develop your internal controls and mechanisms in this enterprise. But at the same time, the firms that are operating in a larger scale, they are expected to develop appropriate resource, mechanism in complete with various, software and other necessary resources to help and check for various sanctions and other screenings. And second aspect here is that client due diligence. So then after you have a proper risk assessment, you can classify your clients into either low risk or normal clients or high risk clients. And accordingly, you can tailor your client due diligence in line with their risk categorization. So what does CDD entail? It goes without saying, first one, in case of legal entities, you have to identify, get the data. I mean, about all the statutory documents such as MOA, AOA, certificate of registration, deed, etc. You need to establish who is the beneficial owner. If you ask FIU, we will say that it is 10% who is holding the threshold of 10% stake. They are all the beneficial owner. But that is very simplistic view, if you ask me. There may be the control may be exerted by somebody else. That we will not know unless some professionals like you, say chartered accountants who have close ties with them and who regularly interact with them. Only they have insights on the such actually who exerts that control on these entities. So that is something that was a major intent behind making you all part of this PMLA. So we expect you to dig deep and make sure your due diligence covers who is the beneficial owner, who exerts a control over it, either through power to appoint senior management, or through debt, or through convertible debt. So you need to have some idea about who is exerting control on it. And in addition to that, second, we have to also do due diligence, whatever is possible. I mean, reasonable due diligence has to be done on the counterparties to the transaction that your client gets into. So the many times we see we have done due diligence on clients. That's it. It's not the case. In case of certain transactions that are high risk and where you find reasonably complex, you need to do due diligence on your counterparties of transactions also. And beneficial owners, we have already discussed. And then comes the sanction screening. Again, this also depends on the scope of your activity. If you have a cross-border clientele and cross-border services, it is imperative that you screen the your client and the transaction parties to various UNSCR designated lists. So there are two UNSCR lists. One is UNSCR 1267 and 1372. And in addition to that, there is a weapons of mass destruction. We will be covering it later, but still these are two lists. It may appear it's kind of bit very difficult for individual sole practitioners, but make sure that you check, because its lists are available in FIU India website, and also we are sharing it with the nodal officer at Ministry of Corporate Affairs, and I'm sure ICSA would also be holding it. So whenever you have such kind of transaction, cross-border transaction, make sure the parties involved are not featuring in any of these designated lists. And in case of level of CDD, sometimes your relationship may end within one of transactions, and sometimes it may go continue. So when it continues, you have to make sure initially you might have classified a client as low risk, but as you progress, the complexity increases. You may have to revisit it, and you have to accordingly update the level of risk for the client, right? And finally, wealth and source of clients. This goes without saying. Again, you have to make sure you have enough insights on wealth and source of funds for the client. Wealth is different, and source of funds is, I mean, how do they regularly get the funds, whether it is through gainful employment or through any other means that has to be properly documented. So this again, this forms the basic client due diligence. And wherever there are some high risk clients, basis your risk assessment, there are certain clientele who fall under high risk. In that case, you have to have some additional efforts that have to be put on them. So it goes without saying it. It has to be rigorous KYC has to be done. You have to search for some additional open source search or through some tools available like Probe 42 is there, and you can subscribe to MCA 42, and it gives some insights. And there are various RegTech companies offering various tailor-made services, and Dun and Bradstreet is something, and various credit agencies give some opinion on the counterparties. So you have to spend some resources on it. Probably you might be doing it as a part of your due diligence, and also make sure you view it from money laundering lens also when you do this and due diligence. And you have to do a background check in case of complex, unusual transaction. That goes without saying. And review of customers' profile and transactions. Many a time, if frequently the customer is being your legal entity's ownership changes, or somebody else is giving all the directions, and it's all very commonsensical points. So please always be on lookout for behavioral aspects in the customer's behavior. And also trust. Again, you have to always look trust with extra care, because, and particularly if they are dealing with some charity or religious purposes, and make sure that they are registered with the Darpan portal. This is something new which we have been driving it, and every financial institution have been driving it. So I don't think it would be difficult for you to seek the Darpan portal registration details. But make sure you get the details. Make sure all the trusts or whatever that you incorporate, help in incorporating, make sure they get registered themselves with Darpan portal. And politically exposed person. Here also there are certain dichotomy here is that there are foreign PEPs and domestic PEPs. We have a clear definition in respect of foreign PEPs, which is available open source. You can search for FAT of definition. But in case of domestic PEP, there is a gap. I mean, we have not defined in our PMLA, but we leave it to you or your you can evolve a mechanism and make sure you define the domestic PEPs, and accordingly, in a consistent manner, you put in place measures to deal with those clients. Because many a times we see politicians and politically exposed persons are using complex ownership structures to evade investigation and trace the origin and usage of funds. So this is something you have to be very mindful of. So this once you have risk assessment, CDD and EDD covered, I think most of your work is done, and you have to only monitor as your relationship progresses. You have to monitor. That's it. And again, as we mentioned about the counterparty screenings, you have to always search for adverse media, sanction screening, and criminal penalties. Many times you can rely on open source, and as your firm is broader and if it offers various services, then it would make sense to get a subscription of some RegTech companies, or there are various vendors out there who can give you inputs on various negative news and the sanctions related new list details. So for individuals, you can always rely on FIU published data, which is also available with MCA and ICSI. And again, once you have done it, and if you find that there is anything, it's not suiting with your risk profile, which is risk profile of your customer and ongoing transaction, you are obligated to file suspicious transaction report in the whatever format that is prescribed by ICSI to FI India through ICSA. So this is something you have to be very mindful of, and it has to be make sure that there is no tipping off. only the persons who are doing it, only the principal officer and designated director, or in case if there is a large firm, only the AML team. Only these persons can have visibility on the fact that STR has been filed either during, after, or before filing STRs to FI India through SRB. Strict confidentiality has to be maintained. And again, this is something you have to be very mindful, and that if you find anything reasonably suspicious, you may file it, even though it may later turn out to be a false alarm. But you are protected by legal provisions that no action will be initiated on you. Only thing is, it should be nobody outside your AML team should be aware of that fact that STR has been filed. So this is something you have to keep in mind. And finally, maintenance of records. Whatever records that you have to maintain for about 5 years from the date of last engagement, or from the date of end of your relationship. So this is also clear. And finally, we also regularly issues guidance note, red flag indicators, typology reports, and we conduct various thematic studies on various evolving trends in money laundering. So we make it available in our website, and we also share it with ICSI. So you can always, whoever is interested and whoever, I mean, it makes sense to always reach out to them to update your internal mechanism to in line with their trends. And ICSI regularly takes part in our meetings where we have other regulators, law enforcement agencies, and financial sector stakeholders. So it gives us various input. I mean, ideas and various trends. It gives us insights on the latest typologies. So I would request your members also who are participating in this session also, if you come across anything unusual and anything new, you please share the data with ICSI so that it can be discussed with other wider participants, right? And in the same with respect to the Weapons of Mass Destruction Act, it's very simple. I mean, since you are screening for UNSCR list, you have to also screen your clientele and counterparties for WMD list, which is a designated list, which is shared by our FIU India to ICSI. And whenever you find any match with that, you can you immediately write or communicate that immediately, either fax, email to your nodal officer at MCA, and not proceed with that particular service which was sought by the respective client. Once you send the details to MCA, we will take care. I mean, MCA will inform the central nodal officer, which is FIU India, and we will whether if it is right, if it is correct, it's correctly flagged, we will freeze those assets. If not, we will release. I mean, necessary action will be what follow action that has to be taken up will be intimated accordingly. This is generally it is like not for our regular normal activities. We have not come across any serious hits with the WMD list, but you should be aware of it, particularly those who are offering cross-border services, particularly with respect to Middle East, or particularly in respect to DPRK and Iran. Mostly these two jurisdictions are frequently featuring in such proliferation issues. So this is something you have to be mindful of, right? This is what I have told. So this is what broadly, and I will share with this, and I'll also share whatever red flag indicators that we have issued, and also the guidance note that we have issued. So this is a continual process. We are not receiving much inputs from your ICSA. Maybe they are trying to get their members up to speed with this. But once you are comfortable, we expect your comments and your proactive typologies so that we can mutually it will be beneficial. Yeah. Thank you.
Thank you, sir. And
Yeah.
yes, we'll be participating more and more to strengthen the system and to guide our members as well.
Okay. Thank you.
So, our second guest today, CS Shweta Gokarn, she'll be helping us navigate through the national and international aspects of PMLA, its evolution and impact on professionals. Over to you, ma'am.
Hello, good afternoon, everyone. May I request the previous speaker to stop sharing his presentation so that I can share my presentation? Thank you, sir. Is my screen visible? All right. All right, let's begin. So, good afternoon, everyone, and particularly thank you so much, ICSI, for this great opportunity. Um, It's truly a pleasure to be here and addressing the subject that is making headlines almost every other day. And it's also gaining more and more importance given that now even the practicing professionals are under the ambit of PMLA. It's getting traction in terms of the professional circles as well. I would like to state at the very beginning that the topic that we are discussing today is relatively new for many of us. So it is absolutely expected and understandable if there are any ambiguities in terms of the applicability and how we fall under that particular definition of 11 persons, whether we are reporting entity just by being a practicing CS, yes, no. So there are a lot of these questions that we keep on getting when we discuss these matters in the professional platforms. In today's session, I'm going to keep it briefly touching upon the international aspects, how the PMLA law has evolved historically from the international and the national level, how practicing professionals are being brought under this ambit. I mean, my previous speaker has already covered a lot of it, but yeah, I mean, whatever additional points, if I have anything, I would love to touch upon those topics. And I think to begin with, I would like to start with the very fundamental concept of what is money laundering. Because just keeping a larger set of audience that we have today, I thought, let me just touch upon these topics in a brief manner. So on the screen, everyone can see the definition of the United Nations 2000 Convention. Specific things that I have highlighted in the definition is knowing the fact that someone is aware of these transactions or someone is knowingly being party directly or indirectly to these transactions. So what is money laundering? Money laundering is a concept where the dirty money is basically turned into or posed to be a clean money. So any criminals, when they generate a lot of cash through some criminal offenses, ultimately they want to use that money, right? So for that, they will ensure to route that money or that those funds through multiple layers to bring it back to the financial system in a way where they will be able to enjoy benefits of that money. So while this is a UN, definition that is provided by UN, but if you map it with the definition that we have under the PMLA, it almost is a similar. And the fact that any conversion or transfer of property, knowing that it is derived from criminal offense, or any concealment or disguise of the true nature, source, location, movement, or the rights with respect to the ownership property, knowing that it is derived from the criminal offense. So why I'm insisting? Because there could be, chances where, like just giving an example of a practicing professional, he may or may not be aware that certain funds or certain transactions which are being carried out are basically are sourced from the criminal activities. However, that also sets one thing, one legal principle, which is adopted by many jurisdictions that a willful blindness or what they call is a deliberate avoidance of the facts is something will be treated by the regulatory authorities or the enforcement agencies equivalent to knowing or being aware of such information. So one has to be very I would say, diligent when dealing with any such kind of financial activities or transactions. Talking of money laundering, generally, as I mentioned, there are three stages of money laundering. I'm sure a lot of you must have seen the web series called Narcos, which was based on the real life story of Pablo Escobar, who was a drug dealer, right? So if you see his life cycle, or if you see his activities that they have shown in the series, the first stage is, of course, when he generates a lot of cash out of all the criminal activities, especially the drug dealing that he's doing. The first stage that comes is placement, when such generated profits, such profits which are generated from illegal activities, are to be deployed or are to be introduced into the system. So how that is done? It could be the small amounts of cash deposits into multiple bank accounts, or it could be smuggling of the physical cash. I mean, I'm talking about back in those days, but even now, sometimes the physical cash could be like, physical denominations could be uh, smuggled from one jurisdiction to another jurisdiction. So that is the first stage of placement. This is the stage where the money launderers are most vulnerable to be get caught. Because once the money moves from the placement stage to layering stage, and then layering stage to the next stage of integration, it becomes more and more complex for the enforcement agencies to find out, or to be able to track down who are the actual beneficial owners of those funds. So placement, and this is a stage where a lot of the first line of defense, as we call, including the practicing professionals or people who are in the banking systems, who are called as the first line of defense, who could be the branch level employees of the bank, could be, they can play a most important role to identify that this money is something that is derived from the illegal offenses, and that's where this money is being. The criminals are trying to basically place this money into the system. Then comes the layering stage, where a complex transactions are created, shell companies are created just to create such level and layers of the transaction, so that to make it very difficult to identify the real source of the money, where it came from. And once the real identity is hidden, then comes the integration stage, where the money which is obtained from illegal sources will get deployed, maybe in purchase of some businesses. Many times, such criminals would want to buy cash-rich businesses like hotels, wherein the income is mostly generated through cash, so that they can also mix the illegal sources of funds to the legally owned businesses. So the integration stage does not necessarily mean that the funds will get utilized only for illegal activities. They could also be, get utilized for the legal businesses, just to disguise this original source. So that is the basic about what is money laundering, and the three stages involved. Now, talking about the historical perspective of money laundering and CFT, as we call that, combating of the financial terrorist financing. So money laundering as a concept is not really new, but in the late 80s is when it started gaining a lot of momentum, especially in 1988, when the UN Convention recognized money laundering as a global threat. That was the first major step that was taken. And it was especially linked to the drug trafficking. And in the subsequent year, 1989, two major events happened. One is the Basel Committee introduced statement of principles, which then are widely used by the banking institutions in order to support the law enforcement in combating the money laundering. If you have noticed that in the last 2-3 years, especially after the mutual evaluation of India, not after actually, just before the India was subjected to the mutual evaluation, just prior to that, a lot of amendments started coming in the PMLA Act, and around the periphery, even the regulators started coming, like SEBI came up with the AML KYC guidelines for the market intermediaries. But the fact that coming from this Basel Committee's recommendations, banking system has been implementing the KYC norms since a long time. So for them, it has been in place, and I think, in fact, that KYC regulations have evolved quite a bit when it comes to the banking systems. So yeah, Basel Committee, and 1989, another important event that happened is setting up of Financial Action Task Force. I'm going to talk elaborately on FATF, what is it, what is the role, what is the scope, how does it expects the member countries to implement certain things and all. So FATF was established, and followed in that, I think 1998 is when India, as a UN signatory, introduced the Prevention of Money Laundering Bill in the Parliament. 2002 is when the bill was passed in Parliament, which became the Act, and 2005 is when the Act came in force. But then you must be wondering that 2005, when the Act became enforced, and 2023 is when why suddenly professionals were brought into the ambit. What happened during those years in between? So frankly, there were a lot of aspects. So generally, the PMLA or AML regulations, if you see worldwide, whichever jurisdictions are implementing the AML laws, it all gets sourced, or the basic principles are revolving around the FATF's 40 recommendations that they call 40 recommendations of FATF. And one of the recommendation is also about bringing in the designated non-financial businesses and professions under the ambit of PMLA. Why it is needed, how it is done, and all of that I will discuss. But the point is that is one of the key requirements of those 40 recommendations. And that's when I think just prior to this mutual evaluation of India, which happened in 2024, a lot of amendments came in, and that's when I think that was the last leg that was remaining, that was to be done from India's side to ensure that we are thoroughly compliant with the FATF guidelines. That's when these notifications came. There is again a whole plethora of discussions, and Pandora's box open on the discussions on who is supposed to become the reporting entity and stuff that we will discuss in the couple of next slides. Yeah, but the point is, I think to ensure that we comply with those FATF guidelines is when 2023 these notifications came in. So as I said, FATF is an intergovernmental body that sets the international standards. And there are countries which are member countries to FATF who are supposed to comply with these 40 recommendations. We don't have enough time, otherwise, for it will be very interesting even from the academic point of view for whoever is interested in learning about the PMLA law and the international standards, very beautifully drafted in a very simple language. If you go through these 40 recommendations, if you go, in fact, on the FATF's website, the amount of data and the amount of content that is available is amazing. Like, if whoever is interested in this subject should definitely visit the kind of reports that they present and stuff. And similarly on FIU's website as well, a lot of information is available. So FATF, initially, when FATF started, as I mentioned, the initial mandate was limited to basically, it would revolve around the money laundering aspect of it. However, I think after the 9/11 attack happened, the focus was also widened to cover the terrorist financing, because it was realized that the money launderers as well as the terrorists generally use the same modus operandi or same methods when it comes to movement of funds that are being utilized ultimately for the terrorist financing, to ensure that they basically don't get caught by the regulators or enforcement agencies. The key difference between money laundering and the terrorist financing is, while if you see the act or the content of money laundering laws, money laundering refers to only the money that is derived from the illegal activities or offenses, scheduled offenses as we call. However, money that is subjected to terrorist financing need not be from illegal activities or offenses. It could be the money that is generated from very legal activities, legal businesses, but that money could also be ultimately reaching for the terrorist financing. So that's how the scope became wider of FATF. So what is the general objective of FATF? Why it is in place and what is really expected? So the objectives of FATF are to ensure that they spread this AML CFT message worldwide. They are the ones who have these 40 recommendations in place, but at the same time, they will also ensure to monitor if the member countries are implementing these 40 recommendations. What is the effectiveness of these rules or regulations that have been effected in terms of what we call as mutual evaluation for this case. Then review of the trends is very important task of FATF, and it's done at international level. Even as the FIU in India also does this kind of activity where the different trends are highlighted, the typologies are then published so that everyone is aware of what is a new modus operandi that is being utilized by these money launderers. So talking of FATF or FATF as we call, what does it expect for its member countries to do? I think as Sir mentioned that one of the key tasks that each jurisdiction or each country is supposed to do is do the national risk assessment. So national risk assessment is the process where country analyzes the threats, the money laundering threats, and the vulnerabilities of the systems towards these threats. So as you can see, I mean, I have this data available for, I think, from the 2022 National Risk Assessment that was done for India. If you see, back then, real estate was considered as the high threat, high vulnerable, medium vulnerability sector. Whereas point number 8, if you see professionals like practicing professional and like us, were considered as medium low. So depending upon the jurisdictions which are the overall operations in the country, the kind of sectors that they are dealing with, the kind of countries that they are dealing with, there are multiple aspects through which this risk assessment is done. So one national risk assessment is done, as I said, at national level. Then when it comes to institutions, even the institutions or the reporting entities are supposed to do their own risk assessment. Talking of, for example, practicing professionals like us, we are also expected to do a risk assessment of our firm, like the kind of clients that I deal with, the kind of services I'm providing. So if I'm a firm which is providing services, which is providing the nominee of directors, or I'm giving my office as a representative office or a registered office, for example, to multiple entities, or these kind of designated activities, is if it is a primary service that I'm doing, then I definitely fall under the reporting entity. And then also my risk, business risk is also on the higher side, because I'm going to deal with such kind of such kind of activities which are prone or vulnerable to money laundering or these kind of offenses. Moving on. So FATF, as I mentioned, conducts a mutual evaluation. As per the latest data, so every 3 times a year, FATF generally publicly lists the countries which are in the gray area, which are in blacklisted. So recently, I think 13 June, they published a gray list wherein 2 more entities have been added, including Virgin Islands of UK. And the high-risk jurisdictions, which is a blacklist, I think the 3 countries persist, which is there from the February 2025 publication. In fact, India recently, I mean, 2024 is when India completed its evaluation, and the result came out. Speaking of India's mutual evaluation report, India has demonstrated a high level of compliance when it comes to FATF recommendation. So 40 recommendations, India is either compliant or largely compliant with 37 of them. And if you see, the effectiveness of this AML-CFT framework at national level is generally assessed on 11 immediate outcomes, as they call. So there are certain substantial effectiveness, like outcomes which are substantial, which come under the substantial effectiveness. There are certain outcomes which come under the moderate effectiveness. So in case of India, there are few, I won't say gaps, but few, suggested improvements which are around the area of supervision, preventive measures that are required to be taken, and investigation and prosecutions. So India, given the nature and the volume of transactions and operations that are there in the country, and of course, given certain bandwidth issues, I think these have been considered under the moderate effectiveness. If I have to talk of a couple of other countries, I don't want to name, but certain other jurisdictions where I have seen that the focus of the regulators is not necessarily on the top layer of the banking or financial institutions, but it also comes down to supervision or the on the regular basis. Even the reporting agencies like accountants or law firms or even the tax firms are subjected to supervisions by the regulators. So I'm sure in the due course, there will be such situations where the enforcement agencies will reach out. I think the intent is not find fault, but the intent is to ensure that all these reporting entities are actually implementing, the policies. They have the framework in place, and it's not just in, by for the sake of having it, but the team, I mean, at the reporting entities have the understanding of the ML laws, what they are supposed to do of their duties and all these things. So it comes down to that. Next, I'd like to give an overall perspective of the AML legal framework in India. So currently, Prevention of Money Laundering Act and the rules issued thereunder frame the primary framework, under the ML laws. But at the same time, if we have to talk about the ML compliances, PMLA can't be operating in isolation. There are other acts which also are part of the ML overall framework. There are sectoral regulations, sectoral regulators who have issued regulations, as I mentioned. Reserve Bank of India or Securities and Exchange Board of India has come up with this AML KYC guidelines, which are supposed to be followed by the intermediaries or entities which fall under their reporting lines. IFSCA has also come up with the AML CFT KYC guidelines. So PMLA is just not one act, but there are all these other acts which which become the overall legal framework of India as a jurisdiction when it comes to combating of terrorist financing and anti-money laundering related issues. There is one act which you can see in the list is Weapons of Mass Destruction and Their Delivery Systems, Prohibition of Unlawful Activities Act. I'm going to share a slide on that later, because if you see on Institute's website, this is also one of the notification that has been highlighted and notified, which is to be implemented by the members of the Institute. And I mean, it's not just about the practicing CSS, but even the CSS or the company secretaries who are in employment are also bound by what is needed or what is required to be done under this WMD Act. So talking of Prevention of Money Laundering Act, just a quick few highlights that I would like to give is money laundering is a criminal offense. This also comes from the FATF's recommendation that it has to be a criminal offense. And the act should give authority to the enforcement agencies to conduct search, seize, and attach basically the properties which are involved, including the authority that is given to something enforcement directorate to arrest the accused person. Unlike many other acts or regulations where the burden of proof is when on the investigation agencies, in case of PMLA, the burden of proof is on accused. And this is where many times questions have been raised by a lot of lawyers that doesn't it really affect your fundamental right, under the Act. But it has been confirmed by Supreme Court on number of occasions that burden of proof will remain on the accused in this case. Scope of PMLA is very wide. Yes, it covers even the connected persons who are otherwise not directly involved in the criminal act. For example, drug dealing. As a professional, I may not be directly dealing in drugs or not assisting the criminal in dealing with the drugs, but whatever funds have been generated of that profit, if I'm setting up the companies, if I'm creating the shell companies to disguise the origin of such source, even though I'm not directly associated with the scheduled offense, I will still be covered under this the scope of the PMLA. There are a few questions. Will the offense of money laundering be triggered only upon laundering of money? The answer is no, even if you are in possession of such money. And if you read the definition in the PMLA, it very widely covers that even the possession of money, even though it is not yet laundered, but just the possession of such kind of money might come under the purview of the Act. Then, can money acquired through violations under GST law be treated as proceeds of crime? Any guesses? The answer is no, because GST law, income tax laws will get governed separately, and this offense specifically is not covered as a scheduled offense. So only offenses which come under the list of scheduled offenses will be dragged, or which will be covered under the PMLA regulations. Otherwise, this kind of activity will not trigger the PMLA compliances. Then the question, is there any minimum monetary limitation before intimating or before taking action under the PMLA? If I'm not wrong, there is no such mention in the Act or in the regulations. So in spite of whatever quantum of money is involved, PMLA can be attracted. Then the next question is, are accused persons' fundamental rights violated by the burden of proof placed on them by PMLA? I think I already answered that. The answer to this question is no. And this has been confirmed multiple times by Supreme Court. What constitutes an offense? Just a quick one. I don't want to go in detail here, but person shall be guilty of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted in one or more of the following processes. So what processes they have mentioned? Concealment or possession or acquisition or use or projecting as untainted property or claiming it as untainted property. So if you see the kind of activities that have been included, as I mentioned earlier, even if the money is not yet laundered, just being in possession of the property, just being in possession of such money could also drag you under the PMLA regulations. As I mentioned, there are scheduled offenses which have been listed down. So any such offense, if the money is derived out of any of the scheduled offenses, then PMLA comes into the picture. One question that I have noted is, can PMLA be applied to acts which were prior to the enactment of PMLA? Again, any guesses? So the answer to this question is yes. It is a retrospective act, and that's why it is also called as a draconian act, because even though the law came in force in 2005, if some activities which were done say in 90s or stuff, but if the criminal proceeds are still being enjoyed, are still being in place, then in such case, ED has full authority to go after that person. I think in the interest of time, I will just skip this and I'll go further because I know we have limited time. So yeah, what are the key amendments? I'm sure a lot of you have heard a lot of noise in especially the last 2-3 years. And as I mentioned earlier, this came in because India was about to get into a mutual evaluation, and a lot of these aspects were kind of missing threads which were to be plugged in before we actually get to mutual evaluation. So the first one was practicing professionals that brought under the purview of PMLA. Widening of the definition of non-profit organization. If you map the definition which was earlier there in the Act versus now, it has widened. Lowering the thresholds limits of beneficial owners from 25% to 10%. Then introduction of politically exposed persons, Sir was mentioning about, and currently it's the PEPs under the definition have been covered only the foreign PEPs. However, yes, a lot of times you have to also consider the local PEPs or PEPs who are present in India. Though it is not specified under the Act, but if you see, there are many instances where you may come across such situations or transactions where PEPs are involved. So you have to be diligent. Additional focus on due diligence and documentation, pulling cryptocurrency and virtual digital assets in the ambit of PMLA. Until last few years, while crypto and virtual digital assets were already in picture, officially they were supposed to be brought under the PMLA review, and that's what has happened. So we come to this question that why us, and why. I mean, a lot of times people ask this question that why professionals are being burdened with this additional set of compliances. Matlab, jitna already compliances that we are dealing with for the clients, isn't that enough? But I would like to state at the foremost and first, and in a very firm way, that we are not the only ones. And internationally, there are other jurisdictions, like if you talk of UK, if you talk of EU, US, UAE, all these jurisdictions have brought under the professionals. Not necessarily that they have the company secretary as a designation, as a profession there, which is outlined, but maybe their lawyers, their tax consultants, their notary public, their agencies, which are basically involved in company formations and all. So all these kind of what they call it is designated non-financial business professions have been brought under the purview of PMLA Act. I think one of the key reasons is a lot of these professionals, if you see worldwide, whatever activities are being done by these criminals, ultimately it comes a point where they also need assistance of the professionals when it comes to layering or integration stage, say by creation of these shell companies or creating very complex structure of transactions and all. That's where I think the expertise of the compliance professionals or the tax experts are needed to ensure that how a particular transaction gets structured, or how a particular frame or a web gets created wherein we don't come under the scrutiny of any regulators, right? And unfortunately, many times such transactions or such kind of events where criminals have been caught, there has been some direct or indirect link which comes down to the professionals. So professionals are called as gatekeepers, and many times we could be the first point of contact when it comes to these criminals in direct or indirect way, where they would seek our help. And that's when, if as a professionals, if you're able to identify those kind of suspicious activities or transactions at the first layer itself, then a lot of help can be done from our side to the FIUs of the countries. And ultimately, as Pooja ma'am was mentioning, that it is about the matter of national security and financial integrity of the country, right? So instead of taking it in a negative way, that why this additional burden, I would say we should feel privileged that we have been casted upon with this kind of responsibility, where the regulators identify us as one of the key stakeholders when it comes to the AML-CFT framework. I mean, I understand there is an additional set of compliances that you have to deal with in case of smaller firms putting together these policies or stuff. And I think regulator has taken a slightly cooperative or kind of a approach, where smaller firms like one person firm and stuff have been, at least that there is some sense of relief to them. But at the same time, you have to ensure that what is needed is in place. Another debate, I mean, I'm going to talk about these two notifications in my subsequent slides. I think let's get to that, and then I will discuss this particular point that I have been wanting to make. So what really changed our lives is 2023, when these two notifications came. The first one was May 3rd, 2023 notification, which actually covered the relevant persons, and it defined that any such relevant person who is part of, or who is taking part on behalf of client in any of these financial transactions will be covered under the PMLA review. While the intention of the lawmakers might be a little narrower, but the way these wordings were done, it became a little bit of gray area. And I think even today, even after, like, we'll discuss the May 9th notification, it still exists like a little bit of gray area. So what are these financial activities that they stated is buying and selling of any immovable property, managing of the client money, securities or other assets. Many times these kind of transactions, if you see like, in the first couple of numbers, you will realize that as a practicing CS, especially, I'm not talking about CS, but as a practicing CS, I don't necessarily like, do all these activities for my clients. Many times the financial activities are something that will be done by their chartered accountants and stuff. But then we go down, that's where, a couple of these items come in picture, which is creation, operation, and management of companies or limited liabilities or trust, right? This is one of the primary work that any practicing CS would do. So a lot of question marks that just because I'm incorporating in a company for my client, does it mean that I become a relevant person and I become the reporting entity? A lot of noise in those few days before the May 9th notification came in. And the May 9th notification stated that, in fact, while May 9th notification widened the scope of PMLA, because earlier under the relevant persons, only practicing professionals were identified. But in May 9th notification, they mentioned that persons carrying any of these activities. Because what happened earlier, if you see beyond practicing professionals, there are so many consulting firms which are into company formations or giving nominee director services or providing registered office services. So those were not getting covered under the earlier notification. So that's when May 9th notification came in picture, and it specifically mentioned that persons carrying out any of these activities like acting as a formation agent of companies or limited liability partnerships, acting as or arranging for another person to act as a director of company or partner or firm in India, or providing registered office services, and these are the listed activities that they have done. So per se, the overall purview got widened. At the same time, 9th May notification also provided for certain exemptions, which came in as a big relief because otherwise, as I mentioned, there was a lot of gray area. So this notification clarified that routine activities under other laws, for example, where professionals are filing company incorporation forms and their role is limited to giving this confirmation under section 7(1)(b), which basically states that I declare that whatever is required or relevant or applicable under the Companies Act for this incorporation process has been complied with. That's the only certification that as a practicing CS I'm going to certify or comply. So in such case, the exemption is provided. So I would say the practicing firms which are into incorporation only to this limited extent of certification or declaration that the proposed company is in compliant with the incorporation requirements, shouldn't necessarily fall under the reporting entity. However, in my personal capacity and in my personal interpretation, I feel that even though your role may not be directly getting under the reporting entity's purview, many times in such cases, and I'm going to discuss a few red flags that as a practicing professional, when my role is limited to this, I still can identify certain suspicious transactions or activities that are proposed. So even though there is an exemption, however, if I come across such situations, it is my, first of all, moral duty to report such kind of transactions, and not just sit there and say, oh, I'm just merely certifying, so let me not, necessarily do this reporting. I think it will be a great misservice to our own country, our nation. So I think, again, it's my personal view, and we have, if I was representative, and they might want to correct me if I'm wrong. But I think this is the overall understanding that because the intention of law is such that why are we under this purview? That we as professionals understand the compliances or understand the regulations in a better way so that we are able to identify such transactions and report them, right? Another exemption was any services by an employee for their employee. For example, there are such instances where there are group companies and company secretaries who are working under such groups. If they are forming such companies and all, they did not be. They would be exempted from the relevant persons definition. standard lease agreement. If I have my own property which I would like to give or provide as registered office, like basically if I enter into a lease agreement with any entity for that matter, and they might want to use it for a registered office, but I'm going through a proper channel of lease agreement which will be subject to TDS, income tax return, and all of that, then that transaction is also exempted. And of course, persons which are already regulated as intermediaries under PMLA. So SEBI registered entities or entities which are registered, NBFCs which are registered under RBI, they are all already, they have their own set of specific sectoral regulations that they have to comply. So such persons are exempted from this. Now we come to Section 12A of the Weapons of Mass Destruction and their delivery systems. So what is WMD and why again is applicable to compliance professionals like us? So WMD deals with activities which are related to the weapons of mass destruction, either production, manufacturing, dealing in, financing of any kind of activity that is all and around these mass destruction weapons. So what really happens under this act is there are certain designated lists that are generated at national level. Again, and frankly, another thing, as I have mentioned on the slide, that it is a misunderstanding that it is applicable only to practicing CS, even the compliance officers in employment of the company are supposed to adhere to these regulations, to this rule. They need to ensure that the people that they are dealing with, whether the promoters or the partners or the directors, beneficial owners, people who are in control of the businesses, are not part or are not listed in the designated lists. That is one of the thing that you have to do. This is generally part of your customer due diligence process, that you have to run these names of the people through these sanction lists or designated lists as they call. And in case if you come across such situation where any of the party is maybe listed in the designated list, then you are supposed to contact the nodal office and provide this information. This will be my last slide, just to quickly touch upon, since we have the larger audience, that as I mentioned, that even though you may not necessarily fall under the typical definition of reporting entity, but as a practicing CS, many times when you are dealing with the clients directly, you might come across many of such red flags. And in such cases, as I said, it is your duty to flag such transaction. I feel there are so many, I won't say practicing CSS, but there are many such company formation agents, like who have this 1500 mein company incorporated ho gayi. I mean, if you see online, there are so many such firms or consulting firms that exist which provide these services in volumes, right? High chances that these kind of entities are quite vulnerable when it comes to misuse by these criminals, because not sure how the KYC is done. Because especially if you have a client which comes of who comes out of nowhere, like there is no existing existing client who has referred you to this person, or who has reached out to you through social media or through LinkedIn or any of these things. And then first it should raise a question in your mind that why me, and why what is the background of this person. So these are the typical red flags that one needs to consider. I think Nehal will talk about this in detail in her presentation. And just to conclude, that AML CFT is a culture. It's not just a checklist. And as I mentioned, that irrespective whether you are a reporting entity or not. And I think I heard that unfortunately on the current portal that has been provided, hardly any of the firms have registered. Maybe knowingly or unknowingly, you might be a reporting entity and you are supposed to do this. I feel instead of having that fear in mind that what if I become a reporting entity, I have to comply with these things, whether the regulators or the enforcement agencies will come behind me. No, I mean, the intention is not to come behind you, but intention is to finally identify the criminals, right? So I think we have to let go of that fear. We have to start somewhere. It's not that your policies and your internal processes will be up to date and 100% correct on the day one, but I think it will evolve over the period of time. But somewhere that first step needs to be taken. And we have to ensure that we keep a larger picture in our mind rather than just keeping a very myopic approach that why am I getting burdened by these compliances? So I think that's a bit from my side. I'm open to questions once Nehal finishes her. Thank you so much.
Thank you so much, ma'am. Indeed, it's more about looking at AML CFT as a culture and not as a checklist. And now we'll be moving to our next speaker, CS Nehal Thakkar, and she'll be shedding light on the technical aspects of AML CFT guidelines with respect to preparation of internal policies and training structures by the reporting entity. Over to you, ma'am.
Yes, so our joint director FIU and Shweta has set the context. So now I will be directly deep diving into the technical aspects that once you are falling into the notification as a relevant person, what you will be doing. So basically, joint director and Shweta both have discussed about May 3 and May 9 circular, mainly for the practicing professional. Based on that, FIU has issued AML and CFT guidelines for professionals with certificate of practice from ICAI, ICI, and ICMI, and it is available on the FIU guideline website and also on the ICSI website. There are other links also which I have shared of PMLA and prevention of money laundering, maintenance of record rules, and also the link of FIU India FinNet 2.0, where you can get all the sanction list. As our joint director have told that we have not to be registered with FIU directly, we have to be registered with ICSI. Now, how we have to do that we will see. So this has been already covered, but just to summarize that if you are treated as a relevant person under the notification, then you become a reporting entity. And for that, if you are carrying out a financial transaction of any of these activities, then you fall under this thing. And there are certain exemptions also, which Shweta has discussed. So now, once you are very clear that you are treated as a relevant person, what you will be doing, then you will have to register with SRB. For that, SRB has created a portal on our website, ICSI. I will be showing that, and they will be identifying the PCS who are undertaking these activities notified by the notification. And what they will collect only the name, designation, and the main information of principal officers and designated directors. Now, who can be the principal officers and designated director? I will share in my next slide. And ICSI will collect all this information and share it with FIU. So our main point of contact is SRB, and SRB will be in touch with FIU. So ICSI has given this awareness material on the main page immediately after this notification was published in 2023. Now, if you say that where I will have to go and register, so we all are knowing on the online services, we have to go to Stimulate, and where we are doing our registration or renewal, that this reporting entity thing is there, register as reporting entity. When you click that, this general instructions comes where ICSI have clearly laid down this notification and have mentioned that if you are doing a financial transaction, okay, then only means if the activities are there, like Shweta has also told that, yeah, we may be doing incorporation of a company, but we are not directly involved into the financial transaction, then we are falling into the exemption. And there are the red flag indicators also, which FIU has provided, are published by ICSI for the general public. We will see later on. So now, before we are registering, we need to understand that whom we will be selecting as a designated director and principal officer. So if it is a firm, you have to select both designated director and principal officer. So under 2(1)(BA, they say that a managing partner of the reporting firm, if it is a partnership firm. So generally, we majority will have either a partnership firm or LLP or a sole proprietorship firm. So the main person will become a designated director, and any senior person can become a principal officer who will be taking care of the entire AML activity or the AML team if it's a big firm. And for FIU has given a leeway that if it is an individual practicing professional, it is only a principal officer. There is no need to be a designated director. Then FIU has given the full responsibility, role and responsibility under section 4.4.3, and I will be covering overall key obligations of the reporting entity. So now once you fill this thing, only this information will be generated and sent to FIU. So this is the only beginning. There is no need that, you are just setting the process that, you are into the system as a reporting entity. Now, what are your obligations? So yes, you appointed yourself as a designated director and principal officer, and I have for reference given the clauses. You can go through it in detail for additional guidelines, and you have registered. Now the main thing is you have to prepare a AML, CFT and CFP policy. Now this policy also has to be board approved if it is a firm, otherwise it is not needed. Then you have to perform the CDD and KYC, enhanced due diligence and risk review, which the joint director of FIU has also covered in detail, and I am also covering a little bit. Then maintaining records, which he told that it is for 5 years after the engagement is over. Training the staff, which right now ICS means there are different ways you can individually do in your own firm, or you can send them for this kind of a training by ICSI, NISM, FIU. Then perform the sanction screening. I have covered the different links of screening and how to file the STR. So here only the difference is that you will file the STR with ICSI and not with FIU directly. Okay. Then there is a prohibition of tipping off, as sir told that you will be not sharing this confidential information with anybody else. It will be directly shared. You will be not telling your client that your information is being passed on. Then you will be performing the risk assessment, high risk, low risk, and medium risk. And then you, as a one step further, you set up the internal control from beginning for the audit or supervision by the SRB in future. And there should be periodic review of AML and CFT policy, because there will be a lot of amendments. So generally once in a year you can review. If there are no change, you can just mention that there are no changes. Now we go one by one. So main thing will be that if you are a sole proprietor, you will feel this is what should I mention in the policy or for a firm. So yes, not one size will fit all. There will be a different policy for different firms, proprietor, and also the type of the activities, but the basic features will remain same. So you will mention that there will be a designated director and principal officer, what kind of designations will be there. Then there will be a criteria for client due diligence and KYC. So here also ICSI will be coming up with a detailed standardized KYC guidelines. But I was shared ahead also that FIU has provided the list based on which you can check the CDD. Then you will be criteria for identifying and assessing the mitigating the risk. That is most important. You will be doing the sanction screening. Well, these are all the points you will be putting in the policy, and based on the policy, you will be implementing it. Then STR filing, record maintenance, training, there will be no tipping off, risk assessment, audit, and this I have covered majority of the important aspect in my next slides. So how you will be doing a client due diligence. So generally we are collecting the document for the Companies Act. For PMLA, there are specified officially valid document they have specified under Rule 21D. I have created a separate checklist. If we time permit, after the slide, I will show you how you can see it. Then, as sir told that you will be checking that, for example, if the client is from foreign jurisdiction, then there should be a sanction screening for each client. You will be checking that client name is not in the sanction list. Then for enhanced due diligence for high risk client, we both sir and Shweta mentioned about the PEPs, foreign and domestic. The company incorporated with foreign director or shareholder, or company incorporated in gift city, which is treated as an international jurisdiction. So where your you are incorporating a company, but your client is maybe from, blacklist or gray list. I will be sharing the list also. Then you will have to be little careful and you have to put that client into high risk. There can be also the activities also. Like Shweta gave a example that, yeah, drugs is a criminal activity or coming under this, but hemp is basically legally allowed, but you may want to put that under a medium, so you can create a company, but you may want to put that company under medium risk. Or a new startup in India is into creation of drones, but the memorandum says that another partner is going to be from, say, I will say Nigeria. So today only there is the news that Nigeria is signing agreement with Brazil or some other company for defense and agriculture. So the investor from Nigeria is coming and telling that they want to have a business with Indian startup who was into drone technology, and they want to export it. So there you will be putting that client into high risk. So based on the memorandum or based on the type of services they are doing and from where the money is coming, and the way we are telling that who is the main significant person. So we will be identifying that whether they are more than 10% ownership of any company is there, or partnership or trust. And as Sir told, that the main intent is that along with that, they want to see actually who is handling the company. So in case we know, because when we will be structuring the company and something, so we may be able to get that information that that person is not having any stake in that company, but is a decision maker. So the regulator may be expecting that we share this kind of information also based on the red flags and the ongoing monitoring of the client. So in case after incorporation, you are going to continue the relationship and other transactions are also there, which we have discussed, you will be doing that there. So this black and gray list has been shared by Shweta also, but you can keep it ready with you. So it will be one of the due diligence whenever you or your team member is incorporating a company, that any of the investor or a director is not from this kind of a high risk or a gray list jurisdiction. So you will be putting that companies in or the client into high risk area. Okay. So now what is sanction screening and STR filing? So when you have to conduct this sanction screening at the prior to commencement of the engagement, also you will have to do it prior to doing an ongoing transaction. And whenever there is a change of sanction list, so that any change is available on the FIU site also, and even ICSI, the way so told that FIU will be sharing this information with ICSI. So from ICSI side also, the reporting entity should get this details. And you review the red flags which are available on our portal, and you can develop a new typology also in case you feel this kind of a suspicious transaction happen. Whenever you feel that the transaction is suspicious, what you have to do, you have to give this information within 7 working days, file this information with SRB, that is with ICSI. Now, there may be a situation when a professional is CA also and CS also. So based on the transaction, they have to decide that if he is involved into a money transaction, and if it is related to C and he's a CA, then he will report it with CA. Otherwise, he will report, if it is a RPT related transaction, he will report with ICSI. So first, let's go through certain red flag indicators which Shweta has also shared. So mainly the initial ones are checking the sanction list, which I have shared this. So first go through this list. You will get all this sanction list on FIU India guidelines, which is UAPA for weapons of mass destructions. Then ESSER told UNSC 2231 and UNSCR 1718. And the entire consolidated list is also there. And whenever there is a change, they will be publishing that there is a one list entry has been added or deleted. So there are tools also through which you can do. Otherwise, you can also try. There are HTML files and all based on which you can check it. Otherwise, there are tools in the market available where where the services are available on SaaS basis, where per transaction you can check this, and they are very reliable. So now, what are the red flag indicators that you have to first check whenever you are onboarding a client, that whether they are matching with UN list, whether they are a list of individual designated as terrorist under 35(1)(a) of UAPA, where this list, then other criminal or terrorist financing list, and whether they are matching with FIU alerts. Then this are something which you will be observing this kind of a red flags during the day-to-day interaction with the client or during the retainership when you are maintaining the account of the client. That company makes large payment to subsidiaries or other entities within the group that do not appear within the normal course of business. I have not covered many which are pertaining to maybe, the CA will be doing. I have tried to cover pertaining to CS. The company shareholder loans are not consistent with business activity. Wherever you will be, somewhere involved in filing the forms or something. Client receives unusual payment from unlikely sources which are inconsistent with sales. Company is invoiced or financed by organizations located in a country that does not have adequate money laundering laws and is known as a highly secretive banking or corporate tax haven. The complex corporate structure, when the complexity is not warranted. So here the way Shweta is telling that initially you may feel that you are just incorporating a company and you are not involved into a financial transaction. But if you go through in detail the red flag, it will be a really good way to contribute to ICSI and FIU, that you just have to additionally create the policy and have the checklist. You are not all activities you are doing it. So you are just doing additional due diligence. The transactions with companies whose identity is difficult to establish as they are registered in countries identified as tax havens and secrecy. So this is a counterparty transaction. Opening an account that is credited exclusively with cash deposit in foreign currencies, complex or unusual transactions, possibly with related party, and extensive or unusual related party. So these are somewhere we really have expertise, and FIU have already put real estate companies or jewelry companies and all onto the for AMLA thing. So there you can surely help. So for example, your client is a real estate company. You may put that company under high risk. It is not necessary that something is happening, but during the course of time, you can have this due diligence. So yeah, this list are there, and of course there is so much learning that we may have a separate session on how to do a sanction screening, practically how to do that. And so once you have a policy and a proper document in place, first of all, till now we are just appointing a person who is a CS. But now, based on this, we will have to do a little more background check that, yeah, the information will be not leaked or, everything. And there should be a periodic AML training to employees for this KYC, CDD, sanction screening, record keeping, transaction monitoring. So we can do this internally once we build that capacity internally. Else, through this professional training sessions or certifications of SRB, ICSI. There is one more initiative FIU have taken. It is RFAC, which is private partnership, and currently lot of banks, payment aggregators and all are doing, and they have always invited that the practicing CS who are going to be a reporting entity, they can become a part of that and they can get these trainings and NISIMs. So these are the training avenues. And the record have to be maintained for 5 years after the business relationship with a client and the reporting entity has ended or account has been closed. So as sir has told that this is an essential, because anytime they can ask us the records, and sometime we may have to go till other ED level also for providing the information. So in summary, just for the paucity of time, I have taken the session little fast. But in summary, so once you establish that you are a relevant person, you have to appoint a designated person and principal officer. You register yourself with the respective SRB portal. So with in our case ICSI, you adopt the AML, CFP, and CFP policy. I have mentioned all the points which are important in the policy, and the slides can be shared so it can be beneficial to you. How you will be implementing the KYC and risk monitoring. The risk monitoring or risk designing will be different for different firms and proprietorship thing. Sanction screening. For that, of course, you can take help of different tools, and the way sir told, it is highly recommended for big firms, and the proprietorship can identify because the number will be not more, and the STR filing within 7 working days through SRB, and SRB, after the necessary check that this relevant person is holding the certificate of practice and other guidelines, they will be forwarding the report to us. So thank you. And, so now I think we are open for the questions to all.
Thank you so much, ma'am. And I was just amazed at a personal level, I would say, that 3 different people taking up almost the same topic, and yet all of you had to offer so much insight into all the different topics. It was amazing. So I'll be picking a few questions because we have positive time, and I'll not be directing questions to any one of you in particular. Whosoever feels like, you can reply to that. My first question comes that the fragmented regulatory landscape and absence of single one-point control will ensure recurrence of Vijay Mallya case multiple times. So what are the trigger points to plug in this loophole? Does this concern this particular topic somehow? What we're doing right now? No one?
I think it will be best if it comes from the FI.
Then I guess I'll move to the next question. Is there any automation tool that can be utilized in place?
There are a lot of automation tools available in the market, like TrackWiz is there, Excite is there. So I think what we can do, the list of the vendors can be collected from means, can be published by ICSI or can be empaneled with ICSI. So instead of, retelling any single tool.
I think
Yeah.
the only challenge, hello, am I audible? I think the only challenge many times is a lot of systems or a lot of softwares which are in place currently are generally have been generated or created from the usability of banking or financial institutions at a larger scale. But when it comes to smaller firms or smaller practicing professionals, I have my own doubts how many softwares or these kind of tools are really available, which will suit the pockets of the practicing professionals. So I think that's somewhere, ICSI can play that role in terms of at least bridging that gap to, bring some of the vendors who would match the requirements. Because we as a practicing professionals may not necessarily need the top end, type of softwares which have all these 100 features. For us, it may be limited to just 10 features that we really want. So I think that initiative needs to be taken.
Fair enough. This is something that intrigued me as a question. They say whether any professional who helped create a company years ago and right now that company is being used in PMLA kind of activities, is he or she liable? And how? like he created in good faith, but somehow the company ended up being used as a medium for PMLA activities. So
So
what is the reports?
my answer, and I'm sure, sir, you can just correct me if I'm wrong. If the person, if the practicing professional has been able to identify that now that entity is being utilized for these kind of activities, it is better to report now than never. Yeah.
So they can file silently, anonymously for
Yeah.
that.
In fact, reporting will help them cover their own risks. If they don't report, and if then it comes in the highlight of FIU or ED, then in fact they will be asked questions. But if they report upfront, so proactive action will definitely be helpful here.
Yeah, they can also not fail to report, but the problem is that to prove that the bar will be quite high. I mean, it's very difficult to So it is better if he knows, if he is aware of it. It is better to report.
Great. And like I was mentioning the word anonymously, I just realized there was a question here which said that in case if we want to communicate something and we do not want to come forward as a reporting person, is there a medium to do it anonymously? Like, one is that as a company secretary, we have to register as a reporting entity and do all those compliances. But somebody who does not want to come forward, just be a whistleblower, how does that work?
Again, it will be a case of see, even though we don't have a power of, court or this thing, I mean, with respect to civil, this thing, even if he does it anonymously, we will take up a review of that company, and ultimately he'll be self-implicating it, right? So it would be better if he, reports it through proper channel. I mean, so that he fulfills this thing also, and rather than going anonymous. But FIU as an organization, we receive complaints anonymously and we take respective actions also. That is for the information.
And sir, there was this one question that was specifically related to one of your slides, which said that in the risk assessment slide, you said sole practitioners have to do some basic obligations. So, what are these obligations specifically?
Oh, so what I mentioned was that whatever that six major thing that I mentioned in the same slide, that whatever the obligations cast under PMLA, they are no exemption has been granted, whether they are sole prop or it is a big firm. The thing is, though, no, the scale of the resources devoted to AML reporting, that can be scaled down, related to the suite of services that are being offered by the sole prop. If a the CSP is providing services to clients from high risk jurisdiction, definitely he has to upskill, upgrade his resources for screening purpose checks and other due diligence. So it is like our understanding here is that if it is a single sole prop CSP, means he is services may be limited to very select few clients who on whom he has very good understanding, and who he has very good understanding who controls it, who operates those entities. So that is the understanding. Accordingly, they can devote resources to their AML program. So there is no exemption whatsoever, but only the scale I talked about the scale actually.
Okay. This was a nice question as regards practicing professionals. So they say that while acting as a non-executive director, a sole proprietor does not access the day-to-day operations of a company. And as such, a PCS who's acting as a non-executive director, how is he, to report when he's not aware of any data except for the financials at the year end?
So reporting wise, as some previously it was clarified by one of the speakers, it was that only in case of WMD they are expected to report it to the central nodal officer. But in case of so you mean to say the firm that is whatever that question that you raised, it is in respect of
Actually, if simply put, if I am a director in a company, I'm a non-executive director in a company,
okay.
and I don't have access to financials before the year end, or so how am I to know if a company is indulging in PMLA activities and how am I to report it?
No, When you say company, the company means that a CSV company, or it is
No, any other company, any
okay.
entity.
Okay, any other company means that only obligation on you is that to report only the whenever one of the directors or the companies I mean persons associated with the company is related to featuring in a WMD list. Your obligation is only limited to that, because you are an employee with the company. We assume you are working with the company, associated with the company. So there, this whatever obligation that we are talking, it is not. We are not asking you to comply with this.
Okay.
I think I would like to add on this that even though you are a non-executive director, so in terms of PMLA rules, more often the term that is used is nominee director, that you are representing someone, you are acting on behalf of someone, is what a nominee director is like. So nowhere it mentions executive, non-executive directors. So nominee could be a potentially, of course, is a non-executive director, but at the same time, you first have to say, ensure that you are acting, as a nominee of somebody, is like representing someone. But otherwise, being on the board of the company, I mean, we all know that the secretarial standards and the Companies Act also requires to have quarterly board meetings and stuff, right? So no one can claim that just being a non-executive director, I just directly get access to the financials at the end of year. Then what were you doing throughout the year? Being on the board, like you are supposed to know the company, you are supposed to be not actively participating in the company, but at least there have to be some checks and balances if you are part of the board. It can't be like you can't at the end of year say that, oh, I'm getting financials directly at the end of year. No, that can't be the leeway if something is going wrong.
So there was a topic that we had skipped for paucity of time, that was politically exposed persons. We hadn't delved into that in quite some detail, and I have a question for that. So who would like to give some details on that? So does that include ex-MPs, MLAs also, or ex-government officers, or immediate relatives of MPs and MLAs, who all are actually a part of the PEP definition?
That is what I mean. That as there is a wide range of definitions. I mean, we can start with what we can begin with FATF's definition on the foreign PEPs. If you can take it and apply it in Indian case, it would be very ideal. I mean, nobody's stopping the professionals to go and to continue with the same definition. So that's what I mean. It is up to your kind of risk appetite that I would say. I mean, if you are confident that your services are not being misused by PEPs, you can just downgrade that definition, and you can make it a bit more less stringent. But whatever definition that your members come up, it has to be consistently applied. It cannot be today something and tomorrow something else. So that is something that you have to keep in mind. So ideally, I will say if you don't have any definition, if you want to begin with, you start from FATF definition of a foreign PEP. And then accordingly, you just, tweak it to your local context, whatever it is.
Great. A question that usually pops when compliance comes in, non-compliance. What is the penalty of non-compliance?
That's what I always tell to whenever I speak with financial institutions or the now DNFPBs. Our philosophy is that we don't go after non-compliance. We just try to understand the context behind why people are not able to fulfill their obligations. More so in the case of DNFPBs. So, talking about the penalties, director is empowered to initiate for each non-compliance for per each day. He can levy a penalty of 10,000, and it can go up to 1 lakh. But it is not, it can be cumulatively added. You might have seen that recently we have issued some penalties on some virtual asset service provider running to the tunes of 10, 20 crores. So our philosophy is to try to handhold and try to understand, get the information in a mutually symbiotic fashion. And wherever there is like our penalties, that is civil penalties, are proportional to the size of the entity. and if it is consistently failing to comply with it, comply with our obligations and guidelines, we are taking it seriously. Otherwise, we are more very lenient, and we are more trying to handhold and help them improve their internal mechanism. So that is our philosophy here.
Great.
I have something to add here again. And beyond, I think the penalties, monetary penalties that have been mentioned in the Act, I think just imagine yourself that, if your name comes under some non-compliances under PMLA, the kind of reputational damage that you get, because we are in a profession where trust really matters. And if your name as a professional gets attached to any of such criminal activities, I mean, it takes time to prove whether you are really innocent or not. But at least even by that time, if the reputation is damaged, then is something that goes beyond what is you can
Financial
recover
implications.
financially, right?
Yes, agreed. With this, we come to the closing of the session. We have 5 minutes, 1 minute each to all of you for your closing remarks. We'll begin with you, sir.
Thank you, ma'am. Just before giving my closing remark, there was two slides from Thakkar ma'am, and wherein she mentioned in the timeline for filing STRs was 7 days, which has since been amended. Now it is promptly. So that 7 days has been removed and updated as promptly. So I know it's very kind of ideal, but the thing is, once there may be some time needed for ascertaining that suspicion. That is okay, but once you are ascertained, it has to be immediately, promptly. You have to file the STR, right? And coming to my closing remark, I mean, thank you for giving opportunity to interact. And this offers me as FIU as an organization, we get a lot of inputs only when we speak to the reporting entities. It offered us very good insights with the speakers and moderator and the participant as well. So my only request here is that since it's a new sector, new kind of obligation cast on you, always try to find what give your feedback to us so that we can improve it, so that we can tailor our this thing to your requirement. And also we need, you have been structuring various transactions and various legal entity formations, that you have a treasure trove of typology reports, that if you could share it with us, we can take it up with respect to banks and financial institutions, so that we can work in tandem to stop these criminals and from doing abusing our financial ecosystem. So I look forward to continual such sessions, and thank you again for the participants as well.
Thank you. Shweta ma'am.
Hi. First of all, I would like to thank you, ICSI, for this opportunity. It was a pleasure to be on this panel along with these two eminent speakers. I would like to say 2 points in my concluding remarks. The first is, as a practicing professional, as I mentioned on during my session, is we shouldn't look at this compliance as a burden, but I think we should consider the larger picture and keep the national integrity first, at the nation first, right? That is first thing. So I think I'm really hoping that in coming days there will be more number of entities which will come forward and register on the portal. That's the first thing. Second thing is, I think ICSI, I mean, my suggestion is also to the institute that these sessions are great, but I think beyond this, a more detailed and a technical session wherein we can handhold the practicing professionals how they are supposed to do risk assessment of their own firm, how the policies are to be drafted, rather than giving something at a macro level, if we can just drill down to a micro level, is something that should be doable, because so that this fear and the apprehension falls apart, and that's so that more people come forward. Thank you.
Thank you. And we do have a detailed course, ma'am, for 5 days, and we look on all the technicalities. We take up that with the members who are participating in the course. Neil, ma'am.
Thank you very much, ma'am. Thank you, ICSI, and thank you, Ilacharyan sir, for your great inputs to entire practicing professionals. And I think surely now there is much more clarity, and with the guidelines, they will be doing the compliances. Thank you.
Definitely. Thank you so much. A really big thank you to all of you for giving in your time, your expertise, and we hope that we'll be able to contribute more, strengthen the governance structure more, and ensure compliance in a better manner. Thank you.
Thank
Thank
you
you.
so much. Thank you.
Yes.